We're live.
All right, welcome back, everybody, to House Energy and Digital Infrastructure. It is Wednesday, January 21st, and we are continuing our conversation about H527, an act relating to extending the sunset of 30 VSA, Section 248A. We are here today with Chair Janet Hurley of the Land Use Review Board and two of her associates. And we are going to be talking a little bit about Act 250, the criteria and the public engagement process, without going too deep into the weeds of Act 250, which is could take weeks. So we're going to try to stay focused on understanding, sort of in my mind, a little side by side, right? The Act 250 public engagement process, Act 248A. We do have Greg Faber here from the PUC. Who agreed to join us. He already walked us through the 248A process and gave us a similar presentation last week, I think it was. And we do have posted on the committee page today a much more detailed document that can give us some more information on 248A. But Greg said he'd be more than happy to be here to answer questions. So timing-wise, just so you folks know, we are a question asking kind of committee. We have tentatively scheduled at 11 a committee discussion of this bill, but that's not a hard stop. Just, by lunch, we need to move on. So anyway, we'll go around the room and introduce ourselves. Then we'll have our guests introduce themselves, and then we'll turn it over to you to introduce yourself for the record. So I'm Representative Kathleen James from Manchester.
Scott Campbell from St. Johnsbury. Richard Bailey from Lamoille 2. Chris Morrow, Wyndham, Windsor, Bennington. Michael Southworth, Caledonia 2.
Christopher Howland, Rutland 4.
Darren Torrey, Washington 2.
Fran Kleffner, Chittenden 13, Burlington.
In the room.
Oh, good morning. John Grayvant, Regulatory Affairs Director of Vermont Environment.
Allison Descaffi, Vermonters Berkeley Environment.
Dana Lee Perry, DeCrassi Group.
Serena Day, Vermont Natural Resources Council.
Chris Rice, MMR, here for Verizon.
Greg Faber with the PUC.
All right.
And I'm Janet Hurley, the chair of the Land Use Review Board. I live very close to Rep. James, right across the line in Winhall from Manchester. So not too far from Rep. Morrow either. And I'm here with Brooke Dinkeldine, a board member, and Pete Gill, our executive director. So Pete, why don't you introduce yourself, and then we'll have Brooke introduce herself.
Great.
Great. Yeah, Pete Gill, I'm the executive director. I've been for about 3 years. Prior to that, I was over at Norwich University doing compliance and regulatory work. And prior to that, I was for about 8 years associate general counsel for the Natural Resources Board, which was the predecessor to the Land Use Review Board.
Great.
My name is Brooke Dinkeldine. I am an environmental and litigation attorney worked with Dawson Giacomo, Detroit McQuestion, a Central Vermont law firm, for 30 years. I had the benefit of practicing before the Environmental Board, Environmental Court, and then when it was expanded to the Environmental Division. And then also have practiced for about the last 10 years of my practice, which just ended when I took this position, but before the Public Utility Commission. So I do have the experience of representing municipalities, individuals, small and large developers in both venues, both arenas. So you're welcome to pick my brain in terms of differences in challenge of being able to represent folks at either of these places. I have also previously testified on the reauthorization of 248A, as well as the effort to eliminate aesthetics, the standing for individuals, neighbors on the issue of aesthetics, which was a hot topic some time ago, and I think may also be circulating at this point. When I was asked by Senator Cummings to come and testify because she was aware of my experience, I also asked her to invite Will Dodge because he and I were in the middle of a case actually with Mr. Faber on a telecom tower. And we were both concerned about the amount of time, the shot clock, that issue of speed for the developer, as well as for the neighbors and municipalities, because it is such a dominant process. It takes so much effort and resources that the neighbors don't want it prolonged either, nor do the municipalities. So I thought it would be beneficial to get Will and I were on the same page in terms of our goals. And so I thought that that was a very important aspect because we all had very shared concerns about the public participating and the speed at which permits were being delivered to developers. So anything that I can help in terms of my experience and perspective on that, I'm happy to answer any questions.
Great.
So we're going to give you an overview of the process for Act 250. Go ahead and next slide. And I guess I should just add that I come from a municipal planning background and regional planning background. We have 5 board members that are all full-time professionals. And first slide, Rick, why don't you, since you've been part of both of those processes, for, you see that?
Yes.
Okay.
This is, so Act 250 jurisdiction is triggered within our definition of development within the statute, and that's section 6001. And one of the triggers is telecom towers or vertically protruding structures more than 20 feet above the highest point of an existing structure, or 50 feet above or more above the ground level. So Act 250 jurisdiction already exists, always has, for telecom towers. And I litigated them in front of the Environmental Board, the Mount Irish towers that you see at exit 6 in Berlin. Those went through Act 250. I was representing Carl Rinker, and then AT&T came in for the second tower and assisted as an amicus. I also permitted the Hardwick Tower that is on Bridgman Hill Road. That was essential to put there instead of putting it on the on more prominent hillsides that were protected in their town plan. So the process exists. It's a normal Act 250 process. The normal criteria are looked at. The difference with the PUC, it's an optional, and I heard some of the testimony I was able to listen to over the weekend. And I would agree, other than amendment permits to existing towers, I don't know of any significant towers that have been put through Act 250 in, you know, some years after this 248A process came into being. So it's an existing jurisdiction. It's not like you would be transferring jurisdiction to us, but most of the developers choose to go through 248A. Now, 248A has most of the Act 250 criteria transferred into it. Criterion 1 through 9K, I think. Greg, maybe you can help me on that. For PUC, criterion 1 through 9K, is it? Yeah, those are already imported in. And that's part of the analysis and the review of the PUC. And the criterion 10, which is town and regional plan, is also looked at. It's just not specifically talked about as criterion 10, but it's a very similar analysis is this. And there is extra substantial deference given to a town for telecom, either what their opinion or their interpretation, as well as the language in their town plan, or even if they have a standalone ordinance for telecom, or they have a provision in their zoning ordinance that pertains to telecom towers. And instead of them going through that process of permitting at the local level, it can be used to inform, you know, we don't want towers in that area. We want them over there. Might be in the telecom, you know, it might be these are the districts in which telecom is a permitted use or a conditional use. So there is that notion of local zoning being able to plan to put these large, huge industrial facilities in the places within a town that are appropriate. those provisions, those regulations cannot have the effect of prohibiting. Okay, well, we're going to tell you that you can only have it in this one place and it really wouldn't work, that way. So that's the federal preemption part from the FCC, that this is federal law, telecom towers, but you are able to, as a community, decide where best to place these kinds of industrial facilities.
Yeah, just to highlight on this slide, you can see, as Brooke was pointing out, you've got the first language there is how Act 250 would what its jurisdictional thresholds would be for these projects.
If a developer chose that.
If they chose that, and what gives them that choice really is that second area provision that's highlighted in green there, saying that, well, if you've got your certificate of public good, which they can choose to obtain, then it is not development, meaning it is not in the Act 250 bucket. So just to summarize there.
And I did not specifically mention, but Act 250 has jurisdiction, as we just saw, but municipal zoning may have jurisdiction, probably does have jurisdiction if zoning exists. Some of our towns do not have zoning at all. Many of them do not. But if you're going to Act 250, you also have to apply to municipal zoning if it exists. And so I've heard there is concern about that duplicative process. We struggled with that in terms of, that's what we studied over the past summer since we were installed in our positions. We did an appellate study to try to figure out how to speed up the Act 250 appellate process. And it's important to understand that I may be getting ahead of myself and then jumping ahead. Let me have Jenna go over Act 250.
We'll describe
and then we can get
our
back.
presence statewide. So the 5 appointed members of the new Land Use Review Board oversee the program statewide. However, we have 5 district offices around the state that serve 9 districts, and each of those districts is shown a different color on that map there. Each of those districts is staffed, and there is a commission of citizen commissioners, 3 citizen commissioners that the governor appoints. And those are the commissioners are the ones that make the permit decisions. They are staffed by those districts are staffed by district coordinators, an individual who assists all parties through the permit process, and assists the district commission and drafting and developing their decisions, their permits, and the hearing procedure if that's called for. So so we are going to quickly describe the process that Act 250 permit review looks like. So
in a next couple of slides, we'll go through the 3 different processes for this. As you can see here, it's a citizen-based review, as Janet was talking about, where citizens are brought into the process through these district commission proceedings. It's
as well as the commissioners being citizens of those regions.
Right.
So you said the commissioners were elected, appointed,
They're appointed.
professional staff. I can't
They're
remember.
not
Sorry.
professionals. No, they're volunteers, citizen volunteers that the governor appoints for each of those 9 districts. And so we have 3 regular commission members in each district with alternates that serve when one of the members can't, for some reason, serve on a particular permit review.
Okay.
and then staffers, district commissions, and technicians that help facilitate the commission's decision making on those permits.
Okay.
So in that process, when the district commissions, they receive a permit application from an applicant, they would review that under the 10 criteria for Act 250. And those are listed here. We're just going to jump to the next slide really quickly because those 10 criteria, as you can see, are repeated here, but there's sub-criteria within each of those, which comes out to about 32. So as you can see, it's a very comprehensive review, many different factors that are evaluated when the district commissions are determining whether a permit should be granted or not. I'll just say really quickly here that we have about 0.2% of our applications that are denied. So in essence, the commissions are generally finding the applications are leading to issuance of a permit. Here's the beginning portion of the Act 250 review process. I'll just note behind me, I've got a large poster. I'll leave that in the room maybe for the day if that's okay with you all, if you'd like, and I can come pick it up later. But just gives kind of the steps in a lot more detail than what we're providing here. So if you're a detailed person and want to get into that, we'll leave that there. This is kind of the initial part. And what I'll say here is even before this any of this happens, before somebody comes in the door and says, here's my application, we strongly encourage folks to come into our district offices, meet with the district coordinator and say, hey, let's sit down and have a pre-application meeting. Let's talk about the different criteria, how those might impact what my project is and how I want to accomplish that. So that they can hopefully get to that end point of a permit being issued at the end of the process. So after that kind of pre-application, you get to that first orange box there. That's where the application is coming in, and we look at that and say, okay, is this going to be enough information for the district commission? Remember, these are appointed laypersons. Is this going to be enough for them to assess each of those criteria for compliance? And if it's complete, then it moves on. Our staff is required to review that in 10 days and give a completeness determination at that point. Sometimes they will find that, oh, you're missing this or that. We need a site plan. We need something. They get that. They obtain that. That's back in the applicant's court at that point. Once they get that back to us, then we'll review that again, making sure that it's complete for that citizen-based commission to be able to review it. Once that happens, it comes back to, well, at this point, we have the district commission looking at it and saying, okay, which of these three boxes on the bottom of that slide are we going to slot this into? Is this something that is an administrative amendment, a record keeping type application? And we'll get to that at the very end of this presentation. Or is this something that is a minor review process? Or is this something that's a major review, meaning that we're going to have a hearing? So kind of two, and those are the two main application types that we're going to be talking about today, is that minor process and then the major process.
How and where are notices published?
Yeah, so that middle long line there, blue, that talks about that first notice period. So when we receive an application, it's received in, we will make sure that that goes out to the landowner. If the landowner is not the applicant, we'll make sure that goes out to the regional planning commissions so that they can review it. We make sure that goes to the Agency of Natural Resources. Other agencies are often put on that as well. Let's see. Yeah. So those are the main folks that get that first initial, hey, we got an application in, here it is. Lets people know.
So there's not a broader public notice at that time.
There will be,
That's
but
coming
not.
up?
Yeah. So this is just the first determination. Is this even a complete application? It's just been received. So it may have 3 items in it and they didn't realize how to upload things correctly and they need to go back to the drawing board on that. So it's not more broadly noticed at that point, but we will get to that.
Okay.
Mhm.
Yeah. Right.
Zoning, where does that come in? Does that come in later?
That's up to the developer.
Okay.
As
So you don't
we
have
went,
any, you don't have any.
we don't have, no
You don't
coordination. but,
notify the municipality or
No.
anything like that.
So the
actually,
municipalities,
municipality is one
They
of
are
the
on that
notice.
list. I
Yeah,
know
he
that I missed them. I missed
That's
them.
that, and he missed the joiners.
So joiners
So-
come in later. They come in later in the process.
Oh, they don't get this for.
They don't get that first
Okay.
one. So what happens is the applicant will provide that initial application, and with that, they will provide a list of different adjoiners that they have for that, so that we can then get that in the notice process later down the road here. So let's go into the minor review process, kind of that second or middle box there. So this is where the commission has reviewed and decided that, you know, given the application materials that are there, there's not going to be a significant adverse impact to any of those Act 250 criteria. They've reviewed it and said, nope, this can go down the minor application process. There isn't concerns coming from citizen groups saying that this needs to go in a different direction at that point. And once they've done that and the completeness review is set, they will publish it in the newspaper, as you can see there in that circle on the far side. They will make sure that there's notice to all the parties that I mentioned before, or individuals mentioned before. Plus, they will make sure that all those abutters or adjoiners are covered, and then anyone else that is asked for to be noticed, or that the commission feels needs to be noticed in that particular application. So the district commissions do have discretion to provide additional notice to other people.
What dictates the notice period? Because it has that range from 7 to 20 days.
That's within the statute is the notice period.
So you're asking whether the commission says it's gonna be 7 days?
What dictates that? How do you
Right.
choose that time?
Right.
Yeah, so there is different provisions that provide, you know, up to 7 to 20 days, I think, in terms of how we've looked at it on a practical level, making sure that there is enough time. This is what we would call the comment period. So it's been published in the newspaper. It's gone out to all the different potential parties, people that might be interested. It provides them an opportunity to comment and say, do I have an issue with this particular permit? Is there something that I need to request a hearing for? Is there something that needs to be addressed in this process? And that's that comment period. And so we found that range is a good time period in terms of collecting that information. But that is,
I think what he's
bound by
asking,
provisions.
Pete, is who makes the decision as to
Whether it's 7
what the
days
length
or
of
20
time
days.
is for a comment period?
I believe that's commission. Commissions can set that.
And do you
There's
you know-
discretion there.
what average are commissions?
Typically it's 20
Yeah.
days.
Okay.
Thank you.
Yeah, sorry, long way of getting there. Thanks to it.
So then the commission issues a draft permit, and that's what people are responding to in that comment period.
Yeah, so in the minor process, one of the things that they can look at is, do they have enough information to draft the permit and have conditions that would meet all the different criteria? And if they do, they can go down this minor process. And as Janet said, once they've got that draft permit, they put it up for this notice period comment.
So it's during that comment period that any designated agency, a butter, somebody who has standing can request a hearing, or somebody else could come in and say, I'd like status. That's when that all happens.
Yes.
Yeah, you would put
Right.
your comments in during that period.
Right. So if somebody wants there to be a hearing, they would say that. and
That's
give-
their window.
That's their window. And then if a hearing is requested, the commission may agree and put it through the major review process, which requires a hearing.
And the fact that they have drafted the permit gives the neighbors and the municipality the opportunity to see what the conditions are and how they're drafted. And that way they can determine, oh, okay, I don't have an issue because this satisfies the concern that I have.
And the commission, I'm sure, can deny somebody's request for status. Can they deny a request for a hearing?
Yeah.
Yeah.
If, under what circumstances?
There hasn't been a requisite showing that there is a substantial issue or a substantial impact or a potential undue adverse impact.
Okay, so you have to meet in the commission's judgment, some sort of threshold.
Yeah.
Okay.
And I don't think it's wrong to say that on party status determinations, I think that historically the district commissions have been fairly liberal in their acceptance of information and allegations, to give preliminary status, because we also have a mechanism at the end of the hearing process to revisit the party status determination that came in the beginning. Because in the beginning, you're just, oh, this is what you're going to prove to us at the hearing. Then you have, if there is a hearing, you have that. And then at the end, in the decision, those party status determinations are revisited and confirmed, or if they didn't show up or didn't bring requisite evidence, then they might
And we'll show
reject
this,
that.
in some
Yeah,
future
in
slides.
the
So-
next slide. So yeah, just to reorient you there, I mean, you go down the minor process and go to issuance, or you get comments in and requests for a hearing, and then it goes back to the major process. But it can also start with the major process, and that's what we'll talk about on this slide here. So very similar in terms of the start of this process. It is, published, a notice is published in the newspaper. It's sent to the adjoining adjoiners. It's sent to the parties that are designated within the statute that I listed previously. So similar persons in that case. And then there is a pre-hearing conference that is held by the commission, which the public is invited to and may attend. At that time, people can, and we often, the commissions will go through what the process is and remind people about how party status, which we will get to in a moment, but that's those persons that have a certain status to be able to participate in the proceedings. And they can request that party status at that pre-hearing or hearing conference that's being held. And we have forms that kind of outline how that what they need to state in the record or provide to the district commission for that determination. There's often a recess order after the first hearing with information that the commission is requiring, or the applicant maybe makes a few changes during the course and needs to provide that additional information to the district commission. They will review that. Once they review that, then they deliberate and decide the decision that they're making on that particular permit application. And it will be issued within 20 days of that last item being received, or it's denied. And again, those are very small percentage of matters.
Oh, you want a question on
Question?
that?
Did you have a question?
Yes.
I'm gonna wait until it's formulated in your
No,
mind.
I mean, I have.
Oh, okay.
I guess it's more of just a comment on this. I'm really interested in making sure we understand the public process with all of this. And so this is very helpful in that regard. I do have to the surprise of none of you sitting there probably, note that I've had a very different experience in Windham County and District 2, particularly around permitting for critical infrastructure, which I'm hopeful you all are going to, over time, help with processes that things like that don't happen again. So just the period of time and the ease of all of this is not something that I would concur with in my region. So
Right. So what this doesn't show is that there can be multiple recess orders, and that does extend that time frame. So these numbers here, 14 days, 20 days, 10 days, that's not necessarily what you're going to see in the end, depending on the application, what information the commission deems is necessary. Or yes, if an applicant decides to modify a proposal and need to submit new plans or whatever, but yeah.
I wanted to touch on that because I know there's a great desire by some Vermonters to improve the public process related to cell towers. And I understand that there is a different public process that happens with Act 250. So this is helpful in that regard. Just wanted to note.
Yeah.
I don't concur with some of the notions about timelines and ease.
Yeah.
Certainly in terms of the timelines, we we strive to meet those timelines, but, you know, as Janet said, you know, when you have those, you have a hearing, and there's, an opportunity for the applicant to address some of those concerns, then, you know, the clock sort of stops on the Act 250 side and is back onto the applicant side, to provide that additional information or work with a neighbor party to try to come up with a resolution. And the district commissions oftentimes are very flexible in terms of providing that opportunity for the parties to work that out. Could be said that sometimes there's too much flexibility there, but that does occur, and that does change kind of the overall timelines. And this might be a good point just to interject in terms of kind of our processing times for these matters. So I don't have the current data for this last year, but previously we had about a 6 month to 1 year process for major applications. That's the ones we're talking about now with hearings. Certainly outliers in all of that, one way or the other. And then in terms of the minors, it's usually about 3 to 4 months that those are processed from when we deem it complete to when you have a permit in hand. And then the administrative amendments, which we haven't gotten to yet, those are just usually a matter of days on average.
Could you go back?
Yes.
So, yeah, you can tell we're interested in is public engagement. So I'm trying to imagine how this plays out. You know, like for just your average me,
Yeah.
for example. So say there's a Act 250 process unfolding in my community, and I might not be a party, but I would find it of great interest. So I'm obviously not going to see it on the Act 250 database unless I get up every morning and
Check it.
I buy a subscription to the local paper where presumably it would be behind the paywall.
It's usually in the legal notices, so sales and things like that, but you'll
Okay.
see usually in bold, it'll say Act 250 permit, and then it'll
Yeah.
give the number, which you can look up, in
So-
that, in that way. And then one thing I forgot to mention here too, is that with that, at that same time, the applicant is required to post a sign on the property. So if you were somebody in the area that was interested, you would be able to get the pertinent information from that sign. We have a standardized template for that for folks to post on their property. So you could see it from that and then learn more about the process.
Okay.
And
The
then
other place that it shows up is the town clerk's office. So it's posted in the municipal clerk's office as well.
I would think in today's modern world that the way most people hear is that a worried neighbor puts it all over Facebook. Is that how it usually happens?
Often it can happen that way, sure. So
You know what I mean? I'm just curious about how these actually reach, you know, everybody. And it's of interest to me because it's like, how do we get the word out broadly so that folks don't have to go looking for it or digging
Yeah.
for it?
Yeah.
Did you have a follow-up?
I did not, Madam Chair, thank you.
Okay, on we go.
yeah, and then just to kind of jump off of your line of questioning there too, we have another, well, actually, we're going to get into that on party status. So I will save my thought there.
Okay.
So this gives this slide maybe more for reference for you all, but this kind of talks a little bit about what typically happens at a hearing. We have, you know, very adept chairs that will go through. We have a hearing.
You know what, before
script
you
for them.
say
Yeah.
that, so the hearing is typically held in the municipality in which the development is proposed.
Oh, that's good.
So it's, the commissions travel for their hearings, and they often are held in a municipal town hall or,
So they're warned and
so there's, you know, some word of mouth may come out just because it's happening at town hall, you know, so, sorry, Pete.
Yeah, they're warned and they are now hybrid. So people can enjoy them from their living rooms if they would like.
So the commissioners, conduct the hearing.
Yes.
And the coordinator, the, district coordinator, I guess is the title.
Yep.
Would be there
Staffing,
to provide, staff.
Yeah, assisting the commission.
Yeah.
staffing the technology,
Yeah.
making sure the commission has everything that it needs to hold that hearing. Yeah.
Okay.
Yeah.
And just so you know, it's a real hearing where the neighbors can come and speak if they have an issue. They can come and speak and talk. They don't have to pre-file testimony and go find a lawyer to help them figure out how to communicate.
So it's more like a public hearing than a formal process.
It's
It's
pretty
formal.
formal, but but you don't have to have representation. You can just come and the commission will hear what you have to say.
If you're a party,
You can come and speak,
you can.
whether you are a party or not.
Oh.
That it doesn't mean that the commission will grant party status to everybody
Right.
in the room, but yeah.
And before you get to the hearing, there is usually a pre-hearing conference. And that typically is when people come, and if they don't know already, they're given materials so that they understand what the criteria are and how to ask for party status and what kind of showing you need to make. So it's a nice handout so that it makes it more accessible and people understand.
And then public also.
Right. And that's a public, it's like a pre-meeting ahead of time.
Yeah, and often there would be a site visit for a major application. If there were a new tower going up, I would imagine that there would be a site visit, that the commission will hold a site visit. And often that is right prior to the hearing being.
And the balloon tests and all of that were very typical when the district commissions were running those kinds of projects. It was much more, it happened a lot more easily. I think the PUC doesn't do site visits and balloon tests necessarily. So I think that was a very important part of the process because it allowed people to see where is this tower going to be? How can I see it from various vantage points? And it helped really to facilitate information to the community. And it was a very important aspect.
I think in our trainings for our district commissioners, one of the things that we try to stress is that they follow the law and what they need to do for their decision making, but that they're also welcoming and accessible to the public. And one of the tools that they have for that is the hearing process and bringing people into that. I'll just jump ahead to the party status piece. So you do have those statutory parties, and it might even be the next slide.
It is.
Yeah,
Yes.
let's jump there.
If people have questions about how a hearing is held, okay.
And so you'll have these statutory parties, which are listed here. And as you'll notice, these are folks that were getting notice right from the get-go of the application as well. And then you'll also have, we'll go to the next one. You'll also have individuals that are interested in that project and have what they call a particularized interest in that project. So it's an interest that the project is going to be affecting them in a way that can be addressed through those criteria, 10 criteria that we talked about earlier. And if that's the case, then they may be granted party status. But if they're not granted party status, we also have another mechanism, and that's called the Friends of the Commissions. So if there is somebody that is interested in this project, does not have a particularized interest, but wants to provide additional information to the district commission, we allow that to happen through that Friends of the District Commission status.
We're interested on this. So somebody who lives across the way and is concerned about aesthetics, would they be able to gain party status, or would they be second category friends or something?
Yeah. So I mean, the commission would have to go through that analysis to see, but likely somebody it wouldn't necessarily need to be in a butter or a joiner right to the property. If they have and it's an impact on aesthetics. Aesthetics is one of our criteria. If they have an impact from that particularized interest, then they would be able to be granted party status, even if they're not in a butter. But they, yeah,
Some of the testimony we heard on 248A, like some of the abutting landowners, the applicant sent it to the wrong address, or was a previous owner, or there are multiple ways that abutters,
End up not getting notice.
yeah, you, I mean, in the DUC rules, it has to be verified against certain databases, municipal database, whatnot. Is there, who follows up on that to make sure that these people are actually getting notified?
yeah. So we do provide a lot of resources for the applicants when they're providing that adjoiners list to us, so that try to get it accurate on the first go round, right? That they're providing, but somebody could move in the middle of the process, right, or something like that. So that can happen. One thing that our district coordinators do is they do review those lists and try to look on a broad level, especially if there's if it's something that it's really critical, or there's some confusing parts about how that list might look. They may take that a little more critical look and try to figure out where that is. But generally, they're using the applicant is using the resources in our application guide to provide the most recent adjoiners list to us at the get-go.
And are we directing them to municipal data? Or-
It is, I think it's related to the sales of properties and that data.
Oh, for
There is
updating.
there is a database that they can review, and we point them to.
Okay.
And if they're going through zoning and Act 250, zoning also has a process whereby the interested parties list is provided by the municipality. And they are verifying the abutters as well as anyone who appeared at the hearing and participated. Because even if they weren't abutting, perhaps they live in the immediate neighborhood. So it's assumed if someone came and testified at the zoning hearing, they're put on the list to be notified if there's an appeal to the environmental division. So you have sort of those two things working in parallel. I have never seen a problem, or if there was one preliminarily, I've seen them sorted out very quickly at zoning or Act 250. It seems to be a common problem that I recall seeing a number of times at the PUC, and I'm not sure what it is, except for the fact that you don't have the human district coordinator person helping and checking and verifying that information. That's the big difference that I see. Yeah, and I'm not saying that it's like a fault. I think we have an administrative person who works with the applicant who comes in, and we have a special form, write down the abutters, and sit down and look at a map together often. That's what I would do when I had an applicant, make sure, district commission coordinator, did we get this right? And that was in days when we didn't even have, the Vermont Atlas, and you can pretty much figure out who owns every parcel or who recently has owned it, and then maybe just have to update it. So I'm not in any way casting aspersions that like the PUC isn't doing it. I don't think they're structured to have the same amount of detail oriented review.
And not that we haven't gotten it wrong before on the Act 250 side. It has happened, and we'll renote it. We have had to renotice things before, which we will do.
Hand holding through the process seems like a critical thing, and that sounds like that's the district coordinator's job.
Yeah, it's a very it's complex.
Yeah.
There are just so many things that have to be checked. So
Brooke already mentioned this, but the final party status decision is part of the district commission's written decision in the end. So Pete did want to describe the administrative amendment process.
Yeah, just
with-
kind of that third bucket. So these are, again, as I mentioned, these are for record keeping purposes. There's no likelihoods of impact on the criteria when these applications go through. This is a district commission decision. They decide that, yep, that this application should go through this process. But you know, a couple important points here, and these are things that we let our commissioners know when they're making these when they're in their trainings, so that they understand that these administrative amendments don't have a notice to the public or other state agencies in terms of that process. There's not a notice to adjoiners, et cetera, in that process. And again, these are for your record keeping purposes only. So it makes some sense that there isn't more process about surrounding those, but they are critical in terms of making sure that the T's are crossed and the I's are dotted and on the permitting side.
So Pete, probably an interesting question would be, what if there's an existing tower and they're just putting another antenna on it? Would that qualify for an administrative amendment?
So it could or it may not. It does depend on how tall that additional tower might be, or antenna on that existing tower might be. There are some portions of changes that would not be required to have a permanent amendment to it, but other things would. And if it would, then you do have a likelihood of impacts under the criteria. It could be under that aesthetic strike criteria, right? So in which case, an administrative amendment may not be the appropriate permitting process for those.
I didn't.
I was going to say, does that have to do with the height of the tower? Is that the main threshold?
Yeah, I think that's a
critical.
critical one, right? Yeah.
What else?
So there
What
could
else
be
comes to
something
mind?
like an access or something like that. If they were going to change an access or something like that, then you might have transportation issues or something potentially.
So maybe additional infrastructure on the ground or something.
Yeah, if there's a facility within it, yeah.
Okay.
And if there's statutory language on this too, in terms of, repairs or replacement of in-kind parts and things like those would not require a permit.
You good?
Okay.
So what is if the commission denies a permit, does the land use review board listen to the appeal? Or what exactly does?
So right now, no, the appeals go to the environmental court. What Brooke mentioned earlier is that part of the task of this new board was to produce an appeals report and recommendations to the legislature. And we did submit that report in November, and Brooke has testified to now a number of committees on our recommendations, which include not immediately, but sending appeals to the land use review board instead of the environmental court.
You mean not immediately?
We're not ready to take that on right now. We're still implementing Act 181.
Right.
So
just to clarify this, would this be analogous to the de minimis criteria under 248A?
Yes, similar, very similar.
Okay, so we heard that 80-90% of the applicants go through the de minimis process. So a lot of that would be same kind of administrative.
I had a case where it was a church steeple and they wanted to change the materials of the louvers at the top to something that was not wood, which was original. And so they just ran it by historic preservation, and it ended up, going through similar to the de minimis kind of notion at the PUC. If it's a replacement or, you need a new antenna and it's not a material change to a project, it's of some significant aspect.
Right, thank you.
When did the review process start, land review board process? start?
The land use review board was seated almost
January
exactly a year ago.
2024.
So we've been at it for a year.
2020, thank you.
Yeah.
And there's one for each commission.
No, the land use review board is 5 of us.
For
Yeah.
the whole state.
From the whole state, yes.
Okay.
None of us can be from the same county. We have 5-year terms. They're staggered 5-year terms appointed by the governor, but the governor cannot remove us. So
And confirmed by the Senate.
confirmed by the Senate. Yeah.
I guess I would ask, Rep. Morrow asked about, the de minimis, the proportion of permits going through 248A that are de minimis versus everything else. Is there any way of gauging, since actually 50 applies to a lot of other things besides towers, any way of gauging the proportions that are administrative amendment versus minor review versus major review?
So, we don't have a huge data set
Yeah.
for towers.
Yeah.
So, I mean, I think most helpful for you all would be probably towers. We had 2 applications. One was an AA and one was a minor last year.
2 tower.
For tower applications. But what I can tell you is our permits from last year or 2024, majors requiring a hearing was 6, minors 2 majors where they converted, right, was an additional 5, so that's about 11 in that category. And then minors was 229 and administrative amendments was 107. So you're talking, a half of them were administrative amendments out of those minors.
Okay.
Yeah.
Thanks.
Can you speak to the capacity of the system just for new permits, like hypothetically, I'm not advocating for this, hypothetically, if 248 worked to sunset and everything came back to 50, it's a couple hundred applications more a year that you guys will be seeing. Would that strain the system or is there plenty of capacity for that?
I can say that over the course of the last several years, 5 to 10, that the number of applications going through Act 250 has gone down a little bit. So there is that. There was a historical point where we were doing 900 permits a year, a little bit larger staff at that point as well. But now we're in the range of 350 to 400, somewhere in that range. It does fluctuate with construction costs, etc., as you can imagine. So I would say that there is some built-in capacity to work on that. The other thing I would say is that we are at a time of transition and change in our program. And we are tasked by the legislature to report back in 2029 about staffing levels, etc. Because we are going into a tiered system of jurisdiction. There's going to be areas where we have new jurisdiction where we didn't have it under tier 3, and we are having exempt areas within tier 1A. So how those play out in real time will be to be determined a little bit.
Thank you.
Did you say less than 1% of applications are rejected?
Or denied, yeah.
0.2. Is that
0.2,
right?
yeah, a lot
Yeah.
less than 1%.
Yeah.
So why is there this general perception that Act 250 is ruining everything?
That's a very packed question that's packed with a lot of, there are a lot of reasons. One reason that Act 250 gets blamed a lot is that we cannot issue a conditional permit. So if an application requires other permits through, in other agencies of the state, our commissions cannot issue that final Act 250 permit until those other permits are issued. If those other permits are being used to show that the applicant meets the criteria, the Act 250 criteria. So a stormwater permit, for example, so sometimes other permits are holding up the Act 250 process. And so it gets blamed for being really cumbersome for that reason. But it might not be the Act 250 district commission review and process that's really holding something up. That's one of many sort of scenarios.
Yeah, and I think in the appeals study, what we saw from doing a couple case studies of those poster child horror story cases of housing that took, 777 days, one of them to get through. But what we found was it was the appellate process. It was going to the environmental division, how long that took, the discovery, the motion practice, all of those things that delay a decision and drag out the litigation portion of this permitting that we were trying to study and figure out how do we speed this process up. And so, don't forget the Supreme Court can take up to a year or more. That's a possible aspect of all this. The middle portion, which is they leave the district commission, and if they don't like the answer, it gets appealed to the environmental division. And the way that I see these kind of a comparison between the Public Utility Commission versus how Act 250 works is that our district commission makes that original determination and it's a real decision. You have hearing officers that are making a recommendation for a decision to the 3-member commission, the Public Utility Commission. They can either accept it, reject it, or change it and explain why. In our process, it gets appealed to the environmental division, which is a de novo hearing. So you go to somebody else for them to hear and to make a different decision, typically de novo on most of the cases. And
Can
so
you explain de novo?
Sure. So that means when to start with Public Utility Commission, you have a hearing officer that says, this is how I think the case should be decided, and writes out the whole decision. And that's either accepted or rejected. In the Act 250, District Commission makes the decision. If it gets appealed, the court will hear it de novo, blank slate, as if nothing happened below. And so nothing is in evidence automatically, not even the decision that was made below, because that is irrelevant in a sense, because this is a new tribunal. And the applicant has the opportunity to say, here's my case, I want someone else to decide it, not the district commission.
It's going to the other parent.
Pardon me?
It's going to the other parent.
Mom's going to give me a better answer. But the Natural Resources Board, now we are called the LURB, we are now a professional board. We appear in that process as a party, like a neighbor. And we don't get any substantial deference to anything that we say. We're just a party. And but it's an interesting comparison, because when we thought about this appeal study and what do we do to speed things up, it was the problem with the court is it's a court and it's overly formalized, and this is permitting, not a dispute or a war between parties, or shouldn't be. And so what we tried to do was focus on accessibility, speed, and cost. Those are the 3 obstacles to the public being able to engage properly and exercise their due process rights. Now, we looked at the Public Utility Commission model to say, what if we turned our district commissioners into recommenders, and then the LURB decides, and then you can go to the Supreme Court. And the only thing that we retained from the PUC model was what the standard of appeal was once the appellate board, the LURB, would make a decision. What kind of review would the Supreme Court do? And so that's about the only thing that we thought was palatable and helpful from the PUC model. And here's why. Because due process is about knowing the evidence, having an opportunity to be heard, cross-examine the evidence that's presented, and call for evidence in your own favor. That's that's what the essence and fundamental nature of due process. And I'm reporting this from 7 multi-hour meetings with some very engaged people across the spectrum in terms of our stakeholders, looking at this issue and how to preserve the right parts of due process, but still speed things up. And contrary to what I heard testimony before about, well, at the PUC, we don't have site visits, or we don't actually even have hearings sometimes. We can't, and beyond that, how can we reduce due process? Well, we looked at that was upside down. What we wanted to focus on at Act 250 for that safeguard that our district commissions were making the right decision. If we were going to sit as an appellate body, the most important thing was holding a hearing and holding a site visit. Those are the fundamental aspects of due process. And when I hear those are being eliminated, that was what the stakeholder group was trying to focus on as being the most important portion of what you want to preserve. It is not about discovery. It is not about lawyers pushing papers and trying to figure out what you're going to say at a hearing. In Act 250, you get a hearing. At the Public Utility Commission, you get paper pushing for weeks. That I think I listened to Annette Smith's testimony, and a lady yesterday named Donna, I'm sorry, didn't know her last name. But they talk about the harried nature of trying to engage as someone from the public. And I include municipalities in that as well. And this goes to Section 248 as well as 248A. It has become so formalized. It is an arena for lawyers. Pre-filed testimony is nothing more than the lawyers writing what they want the witnesses to say, or the witnesses writing their testimony and giving it to the lawyer and saying, did I say it right? That is the reality of it. A hearing at Act 250 is people coming and speaking, and questions being able to be raised and talked about, and tell us more about this. That is the benefit of due process: hearing, being heard, having your position heard without having to learn how to draft pre-filed testimony and get it in on time. And the other thing is the compressed time period for all of this paper pushing that goes on at the PUC. Normally under the civil rules, if you're served interrogatories, and when I say discovery, I'm not sure if everyone knows what I'm talking about, but in litigation, before you get to a hearing, you want to prepare your case. And the way that you do it is you're allowed to ask questions of the other side. What are you going to put into evidence when we get to the hearing? What's so-and-so going to say? Tell me what your experts' opinions are. What are they based on? All of those questions are asked in interrogatories, which are your written questions that you have to answer under oath. You have 30 days, and then we get to see the answers. Then you have requests to produce documents. You have even interrogatories. I want to sit around for a couple hours and ask you questions in a room before we get to the hearing. That's all litigation process. And what we were trying to do is eliminate the process that is not due process. We are requiring, for example, everybody to tell us what you're going to put into evidence. We don't need the parties to ask each other questions back and forth. We are going to issue an order when they show up that says, tell us who your witnesses are, summarize their testimony and tell the salient points of it, and give us any documents you're going to put into evidence ahead of time so everybody can see them, so that when we do sit down and you come and we have our conversation, the hearing, everyone is informed about the basics of what's going to be heard. That is the importance of due process, not pushing paper, because what happens is on Monday, you're served with interrogatories. You have to answer them, I have seen many times, in 1 week. Can you imagine trying to help pro se litigants or municipalities? Oh, you have 1 week to answer all of these questions. Once that's done, then you have pre-filed testimony, and that's filed. And then questions get to be asked about that. Wait a minute, this is my second round. I want to know why you said X in your pre-filed testimony. There are multiple versions of testimony. You can put in pre-filed testimony, then the other side puts in their rebuttal. Then you can put in more testimony to rebut the rebuttal. They call it surrebuttal. And it gets to the point where I, as a practicing attorney, trying to go in and help on a tower case for some folks that were living near the tower, including a couple 100 feet. Baby's window was near this tower. And so I wanted to cross-examine the aesthetics expert. And the aesthetics expert, it took me 6 documents to review to even figure out all the things that he might say because of this discovery answers. And then there's the report. And then we turn the report into pre-filed testimony and spoon feed it. This is who I am. These are my qualifications. This is my opinion. And it's like, all we have to do is read the report. This is the very issue that Will Dodge and I from Downs, Ragland and Martin, who represents AT&T, I asked Senator Cummings to invite him as well when I testified about this process and how it was shutting out municipalities and neighbors. It is too complicated. It is too expensive. Where I would tell a client in an Act 250 case, we're looking at $15,000 to $30,000 to litigate this at the Environmental Division. The starting point at a PUC case to get involved, even in any way that I can hopefully help them, would be $50,000 to $100,000.
Ask another question.
Mhm.
If only 1 out of every 500 applications is being denied, it must mean a lot that are approved are getting appealed. Is that accurate? People are appealing positive?
Some are appealing positive permits.
Yes. So, and to appeal, you have to have standing.
Yes.
So it's someone who didn't like the project and you approved it and they appeal that. And
Or it could also be the applicant who didn't like a condition. So.
And it
It's
breaks
about
breaks
6,
down
yeah,
about
6 to
half
10,
and
6
half.
to 10 a year or something like that. Another 6 to 10 a year on jurisdictional opinions, deciding whether you're in Act 250 or not. So it's actually a relatively small number that are appealed as well.
so
Yeah.
20 appeals a year
And
between
15's
maybe
been
less,
kind
yeah.
of the max.
15 to 20 appeals.
Well,
Get into this long appeals process.
Right. And what Brooke was describing is the recommendations that we made to the legislature in November to change the way that Act 250 appeals are dealt with. They would come back to the board rather than go to the environmental board. And what Brooke is describing are some of the reasons why the board is recommending that happen.
yeah, what I'm trying to explain is, I mean, you've heard how it's in court right now. When we did the appeals today, we tried to build the best board model that we could. We asked everybody to put aside the debate of board versus court that's been raging for 20 years. And we tried to build the best administrative board model for appellate for the cases that would go on appeal. And we think there are important reasons because the administration of Act 250 and policy is better suited to a diverse board than just one judge kind of situation. So what we did was we tried to figure out how do we change from a court model with all this discovery like the PUC has right now, and slim that down. That's the part that we're not losing due process because we're still requiring that exchange of information ahead of time. We're just cutting out all of the rigmarole that's involved in getting information. And that leads to motion practice. And so we tried to just eliminate that part of it, but being very sure that due process was protected. It's streamlined, but it's protected. And the most important aspects, if there's one takeaway from this in terms of my own personal opinion, after seeing this for 30 years, site visits, a very wise Vermont judge once said, a picture paints 1,000 words, but a site visit paints 1,000 pictures. And I cannot, it is so true. I didn't feel like I would represent my client properly at all if I did not go to every site of every case that I was involved in to see it for myself. And that also pertains to the ability to rule on aesthetics. Aesthetics is more than scenic and natural beauty. It is a sense of place. And that is something that is not talked about that much in the case law anymore. It was long ago. But the aesthetics provision is very important because while that's where most people criticize Act 250 because they call it the most subjective of the criteria, which is true, there is a very structured way to figure out whether or not an adverse impact is undue in this particular criterion 8. The one thing that's very different about criterion 8 at the PUC versus at Act 250 is that the PUC has a trump card. They get to say, yeah, there's an undue adverse impact, which would be a denial under Act 250. But then they get to say, but the public good is more important. It's more important to put a telecom tower in this location. Even though we know it's going to be an undue adverse impact on someone. And I heard some of the questioning the other day I think that there was the comment that, in the end, somebody is a loser in some of these decisions. We cannot accommodate all of the competing interests of, development and protecting the environment or our aesthetics. And that's very true. It's always a balancing act. But that trump card has made it very, very, very challenging. It's another obstacle, yet again, where I, as a lawyer, could not in any way predict any kind of positive outcome if someone wanted to get involved in a telecom case, because it's unpredictable, and that is the wild card that makes it challenging.
Can you quickly remind me, and then unless folks have additional questions, we wanted to leave some time for free discussion, where we are in the Act 181 timeline. This is a pretty expansive overhaul of.
Yeah, so we are currently receiving regional plan pre-applications. So we've responded to 3. We have one that just came in, one that's coming in later this week. There are 11 regional planning commissions. Once they get their pre-applications through our process, they'll start applying for a final determination of compliance from us. We will be doing this throughout the year. At times, we'll be reviewing 6 applications at once. We are working on the Tier 3 rulemaking, hoping to submit final rule to ALCAR in September. The Tier 3 is supposed to go into effect December 31st, 2026, so the end of this year. We are working on Criterion 8C rulemaking as well, with essentially the same time frame. The new road construction jurisdiction trigger is set to go into effect July 1 of this year. So we are working on guidance around the road construction jurisdictional trigger based on the language of Act 181. We produced this appeals report that recommended over time for appeals of Act 250 permits to come back to the board. We also recommended, by the way, that applicants could choose to bring their zoning appeals also to the board. We would also, over time, take appeals from Tier 1A areas that are determined from these regional plan approvals that we're doing. Tier 1B are determined that way. Once the regional plan is approved, we're going to start seeing applications from municipalities for Tier 1A. And so that Tier 1A area exempts all projects from Act 250. Those are growth areas that are going to be identified on these regional plan, future land use maps. And the Tier 1B areas would exempt housing up to 50 units. So the tiers will go into effect as they are approved this year. The Tier 1A and B, the Tier 3 won't go into effect until the end of the year. everything that's not tier 3 or tier 1A or B is tier 2, which is basically status quo plus the new road construction jurisdiction, and the criterion 8C will go into effect as well. We do have some other reporting that we are due to provide you this year. We're asking for an extension on that, basically the tier 2 reporting, though we are still going to report to the legislature next month on accessory on-farm business recommendations.
Do you have any sense of where most cell towers, what tier most cell towers are sited in?
I don't know that I could answer that. I would suspect it would be, I mean, most of the state is going to be tier 2.
Right.
So it's going to be tier 2. But, you know, for instance, Manchester, there were cell tower applications in Manchester in the last year. And both of them were for areas that were probably
1D.
No, it depends, but probably growth areas.
Right.
Yeah.
But then again, we've seen, I mean, I have seen attempts to put towers on top of elementary schools or, you know, right in a neighborhood.
Right.
Which would be no Act 250 jurisdiction, then
Right.
all of
If-
local zoning.
If that municipality opts for tier 1B, then yes, there would be no Act 250 required, but there,
Housing, so it would be.
for housing for
housing,
1B,
yeah.
but, for tier 1A.
Yeah.
When the municipality applies for that exemption, there would be no Act 250 jurisdiction within that municipality.
I mean, any
The
town
question is,
close to that, for their tier 1A area,
it would
would not have any Act 250 jurisdiction.
Right.
It'd be Purely local zoning.
zoning, yeah.
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 Do you have time to hear from Mr. Faber? I have a few questions.
Yeah. That would be great for folks. That was very helpful.
Yes.
Yeah, thank you so much.
And I know I jumped
Free to stick
around an
around.
awful lot, so if you have any other questions or want to talk further to understand some of it, I'll be happy to send you a copy of the appeals report.
So.
And might just
Yes.
tab a couple sections
Yeah.
that might be most
Yeah,
useful.
because we're staying.
Right.
Thank you.
So Brooke was the first one up, and she was. And so she's done too.
All right, let's bring Greg up. Thank you so much for your time.
all.
Thank you.
Thank you.
Yeah, Brooke was.
Would the committee like the outline board here, or should we take that back?
I don't think I need it. Do you guys see it? Maybe somebody take a picture of it.
And we have a slide.
Oh, we have a slide. All
Yeah,
right.
you have a slide
broken
that,
into
yeah,
pieces.
broken into pieces.
Yeah, I wouldn't mind getting that.
Getting a picture
All
of it?
right.
Sure.
Yeah.
Okay.
Feels like you should ask the sergeant at arms that be posted properly in the state house.
Let me just zoom in. All right.
Let's.
All right. Ready? I got it. All right. Thank you so much. Thanks for all your time. Really appreciate you being here.
Thanks for having us.
All right, Greg, as promised.
Would you like me to?
Sure, if you don't mind.
No. Well, good morning.
Morning.
Members of the committee, for the record, I'm in favor of the PUC.
Just have a few questions based on the rules that you provided us that are
Sure.
currently in effect.
Yep.
No, in lieu of the formal rulemaking process, you provided these. which
These
seem
are
quite-
essentially rules, yeah.
Yeah, they seem quite thorough, so.
Yeah.
Hence my questions, because, we've received a lot of comment and testimony that seems like these rules would preclude. So I'm a little confused about the implementation of the rules vis-a-vis people's experience of them. So like, the applicant must submit, the application with all these different parameters that you have. but, like, for instance, one of them is state that any comment, motions to intervene or request for hearing regarding the project must be filed with the commission within the 30-day comment period, beginning once the application is filed. And so, you know, we heard from multiple people that was a surprise to them. With
What
this
was it?
30-day period, that they had to get everything in within this 30-day period. So I guess my general question is, do you, as part of your process, review what the applicant sent to abutting landowners and interested parties to make sure it includes all?
Yes, we do a completeness review
Okay,
within 5 days.
right. I thought I heard you say that. So
It's right in there somewhere.
yeah, okay. So I'm just trying to understand, you know, some of the gaps in here. You know, adjoining landowners, again, the same question I asked the PUC is that it seems like there's not all adjoining landowners get.
I heard that. I'm a little confused by that. So if you can see on page, I don't know, you might have different pages here, but under C where it says adjoining landowners.
Yeah, that's what
The second sentence says the information shall be obtained from the most recent grand list.
Right,
And they file an affidavit to that effect.
right, yeah.
In some instances, maybe one or two over my long tenure with the UC, sometimes the grand list hasn't been updated. So the petitioner is relying on that.
Right.
Sometimes it's not up to date.
Right.
Sometimes people on the grand list don't send their updated information to the town clerk. That can cause a problem as well. But that's basically it. So you're using the grand list, you file an affidavit to that effect. We're assuming that that's correct.
Right, okay, yeah.
That's how we,
That's
interesting.
This is a more general question on public good. The applicant must explain how the proposed project would promote the general good of the state consistent with 30 VSA 202C, which I did not look up, but
yes.
You know, for instance, like a Lake Willoughby tower, which is not a cell tower, it's a radio, two-way radio tower, I think.
That's correct.
Is that accurate? Like, so can you just frame for me how that is in the public good?
Right. So there's a definition of telecommunications that's also in the first part of the rules here. You have to show that you're providing a telecommunications service. That's defined.
And
Two-way radio service does that.
And that by definition is in the public good.
That's correct.
That's interesting. Okay. And then what about the municipal and regional plans? If the project does not comply with the plan, the applicant must explain why not and demonstrate how the applicant has nevertheless given substantial deference to those measures, or explain why there is good cause not to give substantial deference to those measures. I might have misunderstood, but it seemed like substantial deference was like in the statute, like you needed to provide substantial deference to the municipalities.
Unless there is good cause to do otherwise.
Okay, that's the part I missed. And so give me an example of, I'm in I under local and regional plans.
Yep.
Mm-hmm.
Can you explain what
would be an example of not giving substantial deference? Let's say that a municipality has structured their town plan to allow cell service only in one small area of the town. And it would be impractical to build there. Let's say it's below sea level. That would be an example where the municipality is basically prohibiting cell service in the entire town. That would be cause to say, we're not giving you substantial deference to that plan. Something like, because that runs into a federal preemption.
That's my
So that would be one example.
Okay, thank you. Those were my main. Oh, wait, maybe one more. Well, there's an opportunity for the applicant to waive the requirements for advance notice. You're looking at 6 here.
Yes.
What would be, what processes, why would someone be allowed to waive requirement to notify? Does that ever happen?
Honestly, it's never happened. So I don't know.
Okay.
I'm sure you're allowed to make that argument, but I haven't seen it.
Right. And is there anything magical about the 30 days? I mean, if it was 60 days, would that throw a wrench
60
in?
day after the application has been filed for, well, so keep in mind, it's listed in there as well, but so we have certain time guidelines, or they're not guidelines, they're actually statutory requirements that we issue decisions by. So that 30 days is coming out of the 60 days or 90 days that we have to issue that decision. So if you extended that to 60, obviously you got to extend all those other requirements or deadlines. You know what I'm saying? So that's sort of the 30 days comes out of the statute. We didn't invent that.
Right.
But again, it's taking 30 days of the 60 days we have to issue. So if we don't get comments within 30 days, as you can imagine, it's very difficult to stay on time with the 60-day issuance.
That's something.
What's that for?
Just to follow up on that point, is that because this is considered an expedited process versus Act 50 process?
Well, this is an expedited process.
So those
It doesn't
timeframes
really have anything to do with Act 50, but
those timeframes would be based on it being expedited, correct?
oh yeah. Yeah, these are statutory deadlines. We didn't make up these 30 days or anything like that. This is all coming from statute.
Thank you. Yeah.
Rep Sibelian, oh, sorry, yeah, Rep Sibelian and Howard?
Greg, we heard either from you or Director Thompson, that, this ongoing sunset has not allowed reconsideration of any statutory changes that might be a good idea, or rulemaking that might be helpful.
Right. As you can imagine, it's difficult to plan going forward when you know it's going away in June. I'm not here with amendments to the underlying statute because this is going away in June. You know,
So
why would we?
if there were, are you prepared to say, you know, if you were able to update the rules, or we asked you to update the rules, like what you think needs to be updated as part of the rules?
No, we haven't discussed it because this is going away in June. As far as we know, unless this is extended or the sunset is eliminated, it's really difficult to plan and think about, you know, the future and how we would like to amend the statute. We don't think about it much because it's going away every 3 years. So we deal in these little 3-year increments where we do the best we can. We have standards and procedures, which we can change. We have to. This is like the 8th amended standards and procedures that we have right now. So we change it quite a bit.
So you've changed the rules quite a bit.
Oh yeah.
Based on what?
Changes to the statute. There's many changes to the statute over the years since 2007. Things like substantial deference was added later. There's been a whole host of things that are changed.
How long does the rulemaking take for this?
It's not a rulemaking. We can do it by order, which allows us to do it very quickly, which is great because it's going away in 3 years or 2 years.
Sorry, I don't understand.
Yeah. So can you explain that point?
The difference between a rulemaking and an order?
Yeah.
Okay,
Well,
so
Sorry, before you
yeah.
explain it, I wanted to ask why I need to understand it. Is that I thought I just heard you say that these can't be updated or aren't updated unless the statute changes?
no.
So
What I'm saying
I
is
misunderstood,
we
yeah.
wouldn't normally enter into a rulemaking. It's a long year and a half, 2 years. The LCAR process, the Legislative Committee on Administrative Rules, that process is very difficult. It takes a long time. There's a lot of mileposts you have to meet. Takes a long time. A lot of public involvement. And then once you do that, it's very difficult to amend that rule. You're basically going through the same process. Again, another 1 or 2 years down the line. In a contested case proceeding, which we'd have to change these standards and procedures, which are essentially our rules of implementation. We would notice it. We'd invite all the stakeholders in. We'd invite them to file, maybe we'd issue a proposed change, a draft rule. You'd say, what do you think, folks? Everyone would file comments. And then we would issue an order. We wouldn't even necessarily have a hearing on it. We would just issue an order to change this. And that would be the new rules or standards and procedures. So very different than a rulemaking. We're not coming over here to LCAR. We're not submitting it to anyone outside. Obviously, all the stakeholders would have input, but so it's much quicker, much easier to do it that way.
And you have the authority to do.
Yes, the statute allows us to do this by rule or order. So we're doing it by order because, again, the 3-year and 2-year.
And you only do it by order when there's a statutory update. There's no other time that you are looking at this and saying, we
did it once for EPUC when we were implementing EPUC, and we had to change something in here, some of the wording.
And is there a prohibition on what you can decide to do in terms of, so, I mean, if we're, perhaps you're hearing that there seems to be some dissatisfaction with public process. Is that something that you all could decide to?
Of course.
Through order?
Yes.
Without needing anything from us?
That's right.
And do you know why that has not happened? Should we presume that it's not something that
why? What has happened?
The improvements to public process. Should we presume that that's not necessarily position of the PUC?
We're thinking it's working pretty well. There's
Okay.
very few applications that have been denied. Yes, we do have hearings on some applications, and that has increased because of the 3-year headline recently. But typically we get maybe 1 contested case a year. Right now I have 5, maybe 6. I can't remember. But that's because of the 3-year sunset.
I don't understand why you would have a public hearing because of this 3-year sunset. Like, what is, I don't.
Not a public
It's
hearing,
disconnected.
contested cases.
Okay.
So we're just seeing a lot more cases right now. People are trying to get
Right.
things in under the wire.
Right, and so the public is contesting.
Well, there's just a lot more cases being filed. So the probability of having contested cases among those increases.
Okay.
And it happens every 3 years. It's disruptive. Well, for me personally, and for the commission as a whole.
And the rulemaking process, which takes longer and comes back to LCAR for review by order, is faster, and there's no legislative review. It's just.
That's right. Well, obviously you can, you're
Right, here
reviewing
we
it
are.
right now. You can change the statute and
Yeah,
require
no
us to do
formal,
things.
it doesn't come back to
It's
LCAR.
not going to LCAR.
Yeah.
That's
So just to clarify, Madam Chair, like we could change,
the statute.
we could change the statute in any number of
Absolutely.
ways.
Yep.
The PUC can take actions to improve the process by order or,
Yes, of course.
yes, yeah, or you could be asked to do rulemaking.
Yeah, all those things are possible.
Are there other ways in which this process could be changed besides those 3? Statutory order, rulemaking, that's it, right?
I don't think so.
Executive order, probably, I guess.
I mean, we have to adhere to the statute.
Like that.
Right now, our procedures adhere to the statute. This is almost verbatim from the statute. So in order to change our procedure, you'd have to change that underlying statute, right? We can't do things that are not in the statute. We're not allowed to do that. That would be bad.
No, I clearly, we understand that. I mean,
Yeah.
it's implementation of the statute is
Right.
what you're talking about.
Right.
What
And
we're all
this,
talking about.
most of this comes
verbatim from the statute. We've added some things, obviously, just to clarify the amount of notice you need to do, what needs to be included in the advance notice, for example, you know, that sort of thing. But mostly this is coming straight from the statute.
So the ability to change by order would be pretty limited then, actually, because it would, you do it, but there's not much you can.
Not much we can change.
Right, okay. I don't know if this
Yeah.
is.
I think I was, sorry. But so just to follow up with that, we could change statute and require the PUC to make changes by order.
Of course.
Yes.
If you change the statute, we would necessarily have to change it.
Yeah. Yeah.
You wouldn't even have to require it. So we
Well,
would
I
do
mean,
it.
the point being that the direction could be to do these changes by order and not go to the process.
Right. Like right now, we have the option.
But I guess that my more general question was whether you had any reaction to Ms. Dinkeldine's description of the PUC process as being overly legalistic. And
You know, we function as a superior court, very similar to a superior court. We are a court.
Mhm.
We are not Act 250 District Commission. But keep in mind, you go through the town zoning, then you go through the district commission process, and then the case starts over again at the environmental court, if and when it gets appealed.
Yeah, yeah.
So we're kind of at that environmental court level, I guess.
Yeah, well, so I guess the question is whether there's any way of introducing perhaps a somewhat less formal process, similar to what the description of the Act 250 process was, where you're conducting a hearing that doesn't necessarily require all of the sort of pre-file testimony and all.
Well, there are public hearings. The statute requires that the Department of Public Service conduct a public hearing in the town at the request of the town during the 60-day advance notice period. So this is prior to it coming to us.
I see. Okay, so that would be the place for that sort of less formal.
Exactly.
Process.
And oftentimes the petitioner will go to a town prior to even filing the advance notice and say, here's what we want to do. And they'll have hearings with the select board and the planning commission. Whether the town involves the entire town, that's kind of up to the town. But that does happen in most cases. So by the time it gets to us, those things are already done. The town knows about it. And now we're going to a hearing.
Right. The only difference being that in between Act 250 process and 248A process is that every process leads to the PUC, leads to the very formal process, whereas all the appeals lead to district commission, or not district commission, but the environmental commission.
But keep in mind, it's similar in the respect that 90% of them are minors, as Act 250 calls it.
Right.
Or for us, it's a de minimis modification.
Yeah,
so
right.
Very little process associated with that. And even some of the larger ones, those aren't necessarily contested.
Yeah.
It's just.
Well, even if it's not contested, it still goes through the formal PUC hearing.
No. If it's not contested, there's no hearing.
Oh.
There's no hearing at all. No, we just issue a decision. In fact, the statute requires us to do that.
Okay.
We have to issue within so many days. If no significant issues are raised. So there's no hearing at all.
Okay.
I don't want to leave you folks with the impression that we have hearings in all these cases. No, like right now I have 5 or 6 contested cases. We will have hearings in those. But that's it.
Okay.
The other 150, no hearings, we just issue an order.
Okay, good. Thanks for that clarification.
Were you at the PUC in 2017?
Yes.
So, I'm wondering, and I don't mean this question to sound critical, but you know, you've said a few times that, hey, it's a 3-year sunset, it's a 2-year rulemaking process, so that doesn't make any sense. I just wonder if there was any conversation, you know, we're now 19 years into this statute, and I'm wondering if there were any conversation, like when you got to year 10 in 2017, of saying, geez, this thing's been around 10 years. Maybe it's going to keep getting extended. Maybe it actually does make sense. Maybe it's not a 3-year ride we're looking at, but another 10 years and we should do some rulemaking.
You would think, but again, we have this conversation here every 3 years, and the same thing happens. And we don't really know whether it's going to get extended or not. We just don't.
You don't, but once it had been extended 3 or 4 times, I mean, the same thing has happened every 3 years. It gets extended, it gets extended, it gets extended.
Don't
it gets
work
extended,
that way.
It's extended.
I'm sorry.
Yeah.
If there's a sunset, we respect it.
All right, thank you.
Rep. Howard?
We heard testimony yesterday of a single tower or a single antenna on a 140-foot tower, a large tower. Once a tower is built, does it attract other co-locators and the like? And if so, how quickly? And or do co-locators apply for co-location prior to the construction of a tower once it's been approved? I don't have no idea how long it takes to wait for the tower.
Oftentimes, AT&T or Verizon will come in. They have a company build the tower, and it's a joint application. So they're co-locating their equipment on that tower at the same time. Okay. So they're putting it up for the purpose of putting their antennas at such and such a height on that tower. Now, the height below that or above that, that will be available for lease to another company, another provider.
So would it be fair to say that there are companies out there that speculate on building these towers with a single tenant to begin with?
I think that some companies have a business plan of offering co-location to other providers. I think every tower that goes up, you're kind of obligated to provide a co-location space.
Well,
The statute encourages that.
The map exists. I picked on last weekend on some of the green spots and saw that the a telecommunications company was on it, but maybe the owner was somebody else whose name I didn't recognize.
Oftentimes, AT&T and Verizon will use tower building companies, like I said. So they'll come in with a joint application. It'll be tower company and AT&T.
Yeah.
But basically, that tower company is a subsidiary of the parent company, like AT&T or Verizon. Because they're not in the business of building towers. They're in the business of providing service. So.
Yeah, could you explain a little bit more? You said you had 5 contested cases. What is involved in that? I mean, are we having municipal saying we don't want it here and stuff
Yes,
like that?
all of those municipal saying no, 5 or 6 people in the town saying no. Yeah, that's basically it. Towns don't always get involved. Sometimes it's just adjoining landowners or just folks who live in the town who will file motions to intervene and request a hearing in the case. But in the 5 I have now, I think the towns are involved. But I can't talk about those cases. Right.
Okay, Favor, thank you so much.
Yeah, you're welcome.
Thanks.
Talking to us. So looking ahead, we did not get to committee discussion. So this afternoon, we have testimony at 1:00 with a super hard stop at 1:15. That's even pushing it a little bit because we have our joint hearing with Senate institutions this afternoon at 1:30 in room 10. So we need to get there. Everybody needs to get settled. Alex is gonna need to be ready to run the tech. So I would just like everybody to make sure that you help me respect that. We need to be down in time for our 1:30. And then where I think that leaves us is we had tomorrow morning at 9 o'clock, we have ISO New England coming in. And I think there's going to be a lot of interest in that topic. So I think it's good to leave them slotted in for an hour and a half. But and then we have the Tinmouth Town Clerk coming in at 10:30. So if folks don't object, I'd like to bump the bill intros and schedule our committee discussion of H 527 for tomorrow at 11:15. Is that okay with everybody? Or just right after Gail finishes, but I'd say 11:15 at the latest. We should shift into committee discussion. So Alex will update the agenda. Alex, did you hear all that?
Yes, got it.
Okay. And that takes us to lunch tomorrow. And then we'll see how the rest of the day goes. We're going to walk through the bill that I requested about the copper to fiber transition tomorrow. Maria has that drafted. She's getting some feedback. We're going to walk through the energy code bill tomorrow. That's definitely drafted and ready. And then we have floor at 3. So we could always talk about the bill a little bit more tomorrow afternoon if we have time. Okay.